Carrie, you're on WSJS with Mike Wells. Good morning.
Good morning, Mike.
Yes, ma'am.
This is Carrie. I want to ask you a question about wills versus trust. I was talking to a banker friend this week, and she said that more and more people who have small estates are doing trust. What would you say concerning the trust versus a will?
Well, I think you still need a will. In other words, even though you have a trust, you're going to have a will because no one ever really gets everything fully into the trust, so you need a will for any other items that are not included for whatever reason. I think generally you have to have a fair amount of assets, liquid assets, a few $100,000 to justify the legal expense of setting up a trust. What I see a lot of folks doing now, assuming that they have a family situation, let's say that a spouse is gone and you have 3 children, each of whom is going to get a share of your estate. If you have an account, either a brokerage account like at a stockbroker account, or you have a checking account or savings account, you can designate on those assets that upon your death, those assets go directly to those individuals. It's called a payable on death or POD account. And it's like somewhat like a life insurance policy in that you have a designated beneficiary, and so that asset therefore would pass outside of probate. So basically that's what a living trust or revocable trust does. Whatever assets are in there, it passes outside of probate. So with these I say in the last 3 years or so, they've expanded the use of these so-called POD accounts to stock brokerage accounts. So when you take most sort of regular folks, their assets are going to be life insurance with a designated beneficiary outside of the estate, retirement account, designated beneficiary outside of the probate estate, and then your main money accounts and your asset accounts, your stockbroker and your money accounts. If you can put POD, it's going to get you there. It's going to get you there. So that's in essence like a revocable trust, so to speak. It's not a trust, it's just something that avoids probate. Now, you need to coordinate all of that with your estate planning attorney so that all of that has an integrated plan that all works together. The worst thing you can do is have a plan and then not have that work together. In fact, I just did a column for the Winston-Salem Journal this past Sunday, just a couple of days ago, in which I talked about this issue. More and more I see folks who are leaving monies to their children in trust because they have an addiction or that they're not good with money or they're getting some sort of governmental benefit that is means test. In other words, if you own anything, you don't really qualify for that. So if you have all that set up and then you have this POD thing and it goes outside of that, then you've got some issues. So the point I want you to remember is, one, you can get there maybe without a revocable trust and a lawyer's expense, but 2, you need to coordinate all that.
Well, let me ask you this. Is there anything you can do about your house?
Well, yes, ma'am, there is something you can do about your house, but your house normally is not going to be subject to probate expenses. It's a probate asset, but it's not going to be subject to probate expenses unless it has to be sold to pay your bills. So if you own your home, which is the main asset most folks have, then that is not going to be subject to a probate fee, as I say, unless you have to sell it to pay your bills. So your home is not going to be a big cost item whether you have a revocable trust or not.
Okay, so the house, if you don't have any bills, so it has to be sold, then it would not be in probate, right?
Well, it would be part of probate, but it's not subject to fees and the kinds of things that would normally kick in the cost, which is what most folks are concerned about.
My thing is, I want my children to have as much as they can.
Yes, ma'am. And that's so I think you've got a plan, but I say you can coordinate that, and that's what I see. And as I say, we set up a lot of revocable trusts, but you just have to look at it and say, is this really justify the circumstances? Because normally when you set up a trust, you're talking about $500 a person, and so part of the lawyer's responsibility is look at this and say, well, can you get there a different way and not have to incur the expense of setting up that trust and also keeping up with the trust? It's not a big thing to do, but sometimes it's just sort of off-putting to folks to say, well, I didn't really understand what this trust thing is anyway. And so anyway, get with your lawyer and coordinate all that. But I think you can get there possibly without setting up a trust.
Well, you're my lawyer, so I'll be calling.
Oh, okay. Well, you have chosen
well.
Chosen well, maybe.
All right, Carrie, thanks a lot for calling. 777-1600, 777-1600. Steve, you're on WSJS. Good morning.
Hi, guys. How's it going?
Doing good.
Hey.
What can we do for you?
I got a question about liens. I'm a painting contractor and have never run into this problem before. Painted a job and pretty much fulfilled the contract and got to a point where there was just a little bit of touch-up left on the job. And the homeowner has decided not to pay the remaining balance, which is about $1,000, and will not let me come back to fix the problem. And wanted to be able to have some leverage in order to do that, to get that job paid for. When the job was first started, their primary residence is here in Winston-Salem, and they're buying a house in Lake Norman, which is the job that I was actually physically working on. And that house is still for sale. I wanted to know whether, if I apply a lien, if I'm able to apply it to the house that is for sale here, in order to have some leverage to finally get paid for a job that they're. How
long did you work? When was the last time you worked on the house down at Lake Norman?
It's been about a month. It's been a little over a month, about a month and a half.
Okay. Well, to your last question, you wouldn't be able to put a lien on the house here for work you did at that other house. If you got a judgment against the folks, you would be able to get that judgment registered against in this county and therefore be a lien on the house here. But the actual lien part, what you need to do is you need to file something, and there's some time limits on it, and you'd have to get a lawyer to help you on that. But you can file a claim of lien. I think it's within 120 days that you last worked on the material, worked on the site, and then within a certain period of time, I think normally 60 days, you have to file a lawsuit. And if you prevail on that lawsuit, then the judgment that you get jumps back to the time you filed the lien. So now you need to check all those dates and all, but that's the last time I've checked on that statute. That's generally, so you should be okay on your time. Now, you're going to spend probably $150, $200 to get a lawyer to help you do that lien.
Right.
And maybe that's a good thing for you to learn how to do, and you're going to have to file it in the county in which the property is located down there, Lake Norman, Lincoln County, or Mecklenburg, or whatever the county is that the property is located. But you may just want to, just file a small claims action against the folks in the county. You have to file that in the county in which they reside.
Uh-huh.
But you could file a lien. You could file a lien, but you'd have to file it on the house where you did the work.
Oh, okay. So I don't have. I wouldn't be able to block a sale with a lien on the one for sale here in Forsyth County.
Not likely. I mean, there are some things, some extraordinary circumstances, but I'm not sure that those would apply based on what you've told me. But and plus, the legal expense of it would outstrip what you would want to save. So, but at any rate. You need to get right on it. And do the people still live here?
No, they've since moved to the other property in Lake Norman.
Yeah. Well, I would look about maybe filing a small claims action against them down there in the county in which they live.
Okay. And
try to move it along quickly.
Will I be, if I file and want a judgment, will I be liable? I mean, will I be able to reclaim lawyer expenses, time spent on this? You
probably wouldn't be able to get lawyer fees, to my knowledge. Generally, you can't get lawyer fees except on a note with certain provisions in there. But a small claims action is something you could file on your own without an attorney. Mm-hmm. Do you have access to the internet?
Yes.
If you go to our website at wellsjenkins.com and on the right-hand side where it lists various remedies available, if you click on that, you'll find your way to a website that the Administrative Office of the Courts has about how to file a small claims action. It's the kind of thing that's set up so that you can do that on your own.
Okay.
Okay?
All right. Well, thanks, guys. I appreciate it.
All right, good luck to you. I'm sorry that's happened to you.